Started today. Welcome everybody back on a Monday. Glad to see those are here and a few of us that are online. So today we have a couple of bill hearings. We'll start out with the hearing on Senate Bill 366, and we'll ask Natalie to give us an overview.
Thank you, Mr. Chairman. Senate Bill 366 would specify that the crime of burglary includes, without authority, entering into or remaining with any locked or secured portion of any dwelling, building, or other structure with the intent to commit another crime therein. The bill amends KSA 215807, that's the crime of burglary. Current law there prohibits without authority entering into or remaining within any dwelling, building, or other structure with the intent to commit another crime within. This bill would add language of any locked or secured portion of any of those types of structures to all those structures that you see in the crime of burglary. And I can answer any questions.
Questions for Natalie? All right, not seeing any. Thank you, Natalie. Oh, Representative Heiberger's hand is raised, actually. Go ahead.
Natalie, have we seen this bill before?
Representative Heiberger, Mr. Chairman, I actually don't think you have seen this bill before, to my knowledge, but the proponents may be able to correct me if I'm wrong, or you also may be able to do that.
All right, we'll go ahead and welcome Todd Thompson, Leavenworth County Attorney, on behalf of the Kansas County and District Attorneys Association. Todd, welcome to committee.
Thank you, Chairman. Representative Heiberger, I do not believe you've seen anything similar to this. This has come about due to recent case law where there was a burglary charged within a church. Obviously, you know, a church is an open accessed facility. And what the person did is went into a locked, kind of locked closet-like area and took out several things, which a burglary was charged. And due to the particular of the statute, it could not be charged as a burglary. The rationale of charging this is for protections of multiple businesses and entities like this, where allow people to come and go as they please, but have specific areas where they lock and assume that visitors that would come into the facility would not have access and should be look at a more harsh penalty, because they should know that, you know, there are particular areas going into a business that you shouldn't have access, and there's a reason why they would have something like this closed or locked. It's kind of, and it, you know, the reason why we are trying to protect this is better protect businesses and places like our churches, and to give them allowances, allow people in, but a sense of privacy and an expectation of privacy where they can hold their items and not have to worry about the general public, and add more severe scrutiny for those that would violate something that would just seem more common sense, that you shouldn't be allowed back there, much less, you know, you should not be stealing. And that is the purpose and the reason why this bill has been brought forward. Law enforcement agencies, and I believe Mr. Klump is there to testify as well. I know he's provided some testimony, but it's the reason and rationale. I believe that you saw in the report from Scott Schultz that this is not a highly financial risk or for our state, but I think it provides a much more benefit and a protection that we should have already had. And I do believe there are some other states that have similar laws. I stand for any questions, and I appreciate the opportunity, particularly appreciate the opportunity that I can do this by WebEx. Thank you.
Certainly, thank you. Committee, do we have questions? Representative Wheeler.
Thank you, Todd, for appearing today. I appreciate your testimony. Could you please familiarize me with the rationale of whatever court it was that found that entering a church and then breaking into a locked closet does not constitute burglary under current law? What was the rationale on that?
Because instead of it being and as you are familiar, Representative Wheeler, with your many years of experience, a locked bedroom could be seen as its own entity if you were renting it. They did not consider a locked kind of closet or a room in this scenario as a room that is separate and distinct in the definition of kind of a dwelling through the burglary statute.
So something happened in the law along the way so that if you put a lock on something, that's constituting another portion of a building that does not include the building itself? Is that what I'm hearing?
It's
'Cause
state v. Glover.
it's
It's
entering the
state.
building with an intent. And if you enter with an intent and then break into the closet, that used to be burglary, and it is not anymore, I understand.
State v. Glover, 56 Canap 2D 1234, and it's a 2019 case. And that's the basis for the rationale of why we were proposing this legislation.
I appreciate your thoughts, sir. Thank you very much, and it's nice to see you.
Good to
Thank
see
you.
you as well, sir.
Representative French, did you have a question?
Thank you, Mr. Chairman, and thank you, Todd, for being here. I was just wondering, is this mainly trying to differentiate between burglary and theft? And can you kind of explain to us non-lawyer types the difference of those two crimes? Thank you.
Absolutely, Representative French, and I know you're a well-versed man, but for the others out there, I'll explain it. So a theft is, as Mr. Representative Wheeler was discussing, well, with a burglary is entering and remaining within a dwelling with the purpose of a theft or a felony within. A theft is the taking of property without permission, with no intent to return such property. And so the distinction for this case is that we're merely taking any items, such as opening up a cabinet door or a locked room or something and taking those items. That is a theft. A theft is one of the elements necessary to reach to a burglary. For the burglary, you actually have to enter and remain within a dwelling, a vehicle, or some type of, generally used to be just a rented room or something like that, that you have an expectation of privacy. State v. Glover changed that a little bit and said that just because you have a specific room in there does not mean, and it's locked, does not mean it would be a burglary, yet it would just be a theft. And so that distinction is, a burglary is a more serious offense, as you can imagine, and is, I believe, necessary because it's a more heinous crime with the difference between just a theft and a burglary. So I hope that explained that. I hope I didn't draw on.
Thank you. Representative Smith.
Thank you, Mr. Chair. As I'm thinking about this, I know of at least a couple or three cases where we've run into one. I'll say there's a hotel where you have access to a room, but it has a locked access to a storage area or an HVAC area. I can't remember how that's set up. Also, I'm thinking along Airbnbs where they have locked storage areas within the structures that you have access to, have rented, but they'll have directions you are not to enter these areas or whatever that are locked. And you could get into some confusing law on that with people getting into closets they're not supposed to get into and removing items they're not supposed to. That sounds like it would be along those lines. Am I correct?
Yeah, I hadn't thought about the Airbnb scenario, but yeah, I mean that's exactly kind of the idea. It's also like businesses that you have the back room where you have your storage or things of that nature that also need to have there's an air of protection and should be protected. And that's the difference between changing it from just a mere theft to a burglary, because you're actually having to basically, as the old common law say, break in to a area and then steal the items from within the area that you broke into. And so that breaking in and entering, that is what the crux of a burglary is. The taking is the theft, which is another part of a burglary, but also a crime in and of itself, as everyone's aware.
And thank you. Any additional questions for Todd? Representative Howerton.
Thank you, Mr. Chair. Is there a monetary limit or between burglary or theft? Does it have to be worth so much money to be a burglary?
You know what, and that's a great question. No, it does not. By the purpose of a burglary statute, it is theft or a felony within. A burglary can apply to a misdemeanor theft as well as a felony theft. And so the application of monetary amount does not matter. The theft is a separate and independent crime from burglary, but theft is part or one of the elements necessary to have a burglary. If you can either have a theft or you can have a felony within.
All right, thank you. Oh, Representative French, go ahead.
Thank you, Mr. Chairman. One other question. I noticed in the opponent testimony coming up that they mentioned the fact that if someone broke in and got the master key to a high school's lockers and they opened all the 600 lockers and stole the stuff out of it, then we'd have 601 felonies under this particular bill. Is that correct? Or can you give me some more definition about the number of felonies that could happen under this bill? Thank you.
Well, to answer your question, I mean, any amount of felonies or any amount of burglaries is dependent on how many times they are breaking into something. The concern whether they have 100 burglaries charged or 3 or 1 is dependent on how many the prosecutor actually charges. But in that saying, to have that many doesn't apply to like a sentence. And the way they're phrasing it is it would be really high, but our sentencing guidelines don't work in that respect. Our sentencing guidelines work that we can only sentence double the base of the burglary. So even if they have 100 burglary counts, realistically, they're not going to be sentenced for 100 burglary counts. They're going to be sentenced for probably at most, maybe depending on their criminal history, 2 to 5, if that's even how many they go through.
Thank you for that explanation. Thank you, Mr. Chairman.
Certainly. Additional questions? All right, seeing none. Todd, thank you very much for your testimony today. I will note that is the only proponent testimony that we have. I'm seeing Ed Klump raising his hand, would like to be heard, I assume as a proponent.
As a proponent, yes, sir, and I believe I submitted testimony. I'm going to have to check back. Maybe something went awry with it. So, okay.
We'll make sure that this gets disseminated regardless. Thank you.
So thank you, Mr. Chairman. My name is Ed Klump, and I'm here representing the Kansas Association of Chiefs of Police, Kansas Sheriff's Association, Kansas Association of Chiefs of Police. We requested this bill. We worked over the interim with KCDA on language for it. And as has been stated, it came about because of the State versus Glover case. In that case, it was St. Anthony's Catholic Church in Sumner County that was entered. And so here's the crust of what causes the problem, the way the court saw it at the time, is the language in the current burglary statute is burglary is without authority entering into or remaining with any, then you got dwelling, building, structure, those things. And so in this case, the church was open for prayer and meditation. So they did not enter it without authority. It was open to the public to enter. So they entered the structure with authority. Therefore, that's what caused the problem with the first step of it. And then secondly, there's nothing in the statute that covers subunits within that building or structure. Now, over the course of years, there's been several case laws on this, and the appellate courts have ruled that if that subunit is leased to another person or under the control of another person, for example, if someone enters the mall and all the mall doors or businesses are locked, if somebody breaks into one of them, that is a burglary because it's not under the control of the same people as the building. So in this case, you have the entire structure. So what these two people did was they went into the church and then they broke into the locked sacristy of the church. And once in there, they didn't find anything worth taking. So then they locked in, they forced entry into either a locked cabinet or closet, I'm not sure which, and stole items of value there. And that's where the court said, but they entered this building or structure with authority and there's nothing in there to cover the subunits. In the case law, the court went on to say, and I've got this quote in my testimony, if this interpretation is not what the legislature intended, the law could be changed to more clearly include subunits of a building as being buildings or structures. I found that rather not common to make that kind of a statement by the courts, but clearly I think they were questioning, rather reading between the lines, it sounds like they may have been questioning whether that was the legislative intent. And so as a result of that, that's why we brought the bill forward. So there's been several examples of types of situations this might apply to. Another one that comes to mind I'd like to put out there is rec centers, where they're open for people to come into the gym, use the gym, whatever. But they have locked concession areas. They have locked storage rooms where sporting equipment is kept and things like that. So those are the kind of things we're trying to capture with this amendment. And with that, Mr. Chairman, I'll stand for questions.
Thank you, Ed. Committee questions? All right, check online. Oh, Representative Wheeler.
Thank you, Mr. Chair, and thank you, Mr. Klump. And I can appreciate that this is to remedy a situation based upon a decision of one of our Kansas courts. It's sad that we have to do this. I understand that when you enter a church that is open, you enter and you're welcome to come worship. You're not welcome to come steal. So I have trouble with entering the church with authority when your intention is to steal. I don't think that exists. But then I'm not a court of the state of Kansas, and I appreciate the efforts of coming to us to remedy this situation. Thank you, Mr. Chair.
Thank you, Representative. Any other questions? All right, seeing none, thank you, Ed. We'll make sure you might just resubmit that testimony. We'll get it sent out to everybody. Committee, is there anybody else here for proponent testimony or neutral testimony? All right, I do have written only opponent testimony from Max Iverson of the Kansas Association of Criminal Defense Lawyers. I would encourage you guys to take a look at that. Anybody else here with opponent testimony? All right, seeing none, we'll go ahead and close the hearing on SB 366 and move on to SB 408 and open that hearing and ask Natalie to give us an overview on SB 408.
Thank you, Mr. Chairman. Senate Bill 408 increases the criminal penalties for multiple thefts of mail. The bill amends KSA 215801, that's the crime of theft, to provide that theft of property that is mail of a value of less than $1,500 from 3 separate locations within a period of 72 hours as part of the same act or transaction, or in 2 or more acts or transactions connected together, or constituting parts of a common scheme or course of conduct would constitute a severity level 9 person felony. The general penalty for theft of services of a value of less than $1,500 would be a Class A non-person misdemeanor, so that would bump this penalty up to a felony. The bill defines mail as a letter, postcard, package, or bag sent through the United States Postal Service or other delivery service, or any other article or thing contained therein, or a sealed article or thing addressed to a person. And Representative Heiberger, this bill we have heard before. Last year, House Bill 2229, this bill was actually in the House Judiciary Committee. So you guys did work that out. It got bundled with another bill increasing felony loss thresholds for other types of crimes, and then it was stricken from the calendar. And I can take any questions.
All right, thank you for that. Questions for Natalie? Representative Carmichael.
Thank you, Mr. Chair. The title of the bill would suggest that this only applies to United States mail, but in listening to your description, I think this encompasses more than just United States mail. Amazon package left on the doorstep, I think that that is contemplated as another qualifying theft.
Yes, Mr. Chairman, Representative Carmichael, I think that the title just says mail. It doesn't necessarily specify where it's coming through. But then later on, when we define mail, we do include the United States Postal Service, but then we say or other delivery service or another article or a sealed article or thing that's addressed to a person. So I think it would include all types of what we generally think of as mail.
A follow-up, I generally think of Amazon packages as not being mail. I think of them as packages or parcels, but not mail, but they're clearly covered by this. What if I go next door to my neighbor's house and I drop off a package over there, some cupcakes for the kid's birthday, and the kid across the street is hungry and takes that package? I'm not a common carrier. I'm not a postal employee. I don't work for FedEx, but I left a package on my neighbor's porch. Well, to get it, maybe I left it on 3 of my neighbor's porches. They all had birthdays on the same day. Is that proscribed under this statutory scheme as well? I shouldn't say proscribed. Does it fall within this statutory scheme?
Mr. Chairman, Representative Carmichael, I don't think delivering anything would be prohibited by this statute. Are you talking about if someone were to steal what you dropped off? Okay, sorry,
Correct.
I
Yeah,
misunderstood.
yeah, I drop off 3 packages at Valentine's Day. I drop off 3 packages, and the kid across the street steals all the chocolate candy in the 3 packages.
So the only one that I could see, because the last part there says a sealed article or thing addressed to a person. So I think if you, if you put the Holder family or something on it, then perhaps that could be deemed as being addressed to a person. The clause after or other delivery service says or any other article or thing contained therein. I think that's meant to describe the letter, postcard, package, or bag sent through the USPS or other delivery service, but I'm not completely clear on that. But I do think if it were addressed, it would definitely fall under that last clause.
And Mr. Chairman, the final possibility, I hope the final possibility that comes to my mind is that I drop off my weed eater, but I don't wrap it up in a package. I guess I don't have little Johnny's name on it. I guess that wouldn't qualify.
Mr. Chairman, Representative Carmichael, I don't think so, because that one does say a sealed article or thing addressed to a person. So I think that would not meet the definition. My guess, I mean.
Well, I guess the same way you do. Thank you.
Representative Patton.
Okay, Representative Carmichael led me to a question. So in the scenario he's just outlined, he's not the Postal Service, nor is he a other delivery service, right? I mean, I get that the package may qualify, but if he's delivering himself, does he count?
So I'm not sure that United States Postal Service or other delivery service is necessary for that last clause. I think it, could maybe benefit from being listed out, because I don't think that it necessarily, the last or a sealed article or thing addressed to a person, I'm not sure that it has to be delivered by the USPS or other delivery service. The way that's listed out there.
Okay, thank you.
Representative Howerton.
Thank you, Mr. Chair. Wouldn't the monetary amount for cupcakes disqualify that?
Well, what's happening here is, so right now, to be a felony, it has to be worth $1,500 or more. What we're doing here is saying if you take 3 things that are worth less than $1,500, so they could each just be worth $1. As long as you take 3 different things, then that rises to the level of a felony.
Okay, thank you.
Additional questions, Representative Osman.
Thank you, Mr. Chairman. Well, first of all, to to address what's going on here as well, I see that it's from 3 separate locations. So it wouldn't be just one package of cupcakes. It would be a crime spree of 3 different neighborhoods.
Well, 3 different porches, I think was, yeah.
Okay. My question deals specifically with the USPS. Isn't that a federal crime already? So what's the differentiation between a state level crime and a federal crime as it pertains to the mail itself, the USPS service?
That is a federal crime. I would have to look up what the penalty is. There's nothing that precludes you from criminalizing something under state law that's also criminalized under federal law, but I could look up to see what the penalty for that would be under federal law.
Any other questions? Let's see, Representative Heiberger, I saw your hand earlier. Did you get your question answered?
Yes.
Okay, thank you. All right, well, thank you very much, Natalie. Now we'll be pleased to hear from Eric Stafford, Vice President, Government Affairs, Kansas Chamber of Commerce. Welcome to the committee.
Thank you, Mr. Chairman and committee members. Eric Stafford with the Kansas Chamber, playing committee bingo and marking another one off my list for a committee I've never been in front of before. So good to be here today. And to Representative Carmichael's question, I don't know what kind of communists want to steal chocolate or cupcakes, but I don't think they deserve to live in the state of Kansas if they do. And we should fully prosecute them for such actions. So appreciate the opportunity to testify here in support of Senate Bill 408. It is identical to the original version of House Bill 2229 that was introduced last year in committee, was passed, but there was an amendment included that kept it below the line on general orders, and we were able to get this bill through the Senate without any amendments that were problematic to the bill. But this was brought to us under the Kansas Chamber's umbrella. We have the Kansas Retail Council as well as the Manufacturing Council. So we have a segment of our membership is retail-based, retail-focused. Retail theft is a growing issue and growing concern. This is one of the ideas or policy recommendations that was brought forward last year to pursue, and it is making the multiple thefts of mail equivalent to shoplifting. So I know some of our members had lengthy conversations with law enforcement on how to best to kind of tie up the loose ends in this area, and Senate Bill 408 is what is a result of those discussions a year and a half ago or so. So there's a link in the PDF copy of our testimony for research on retail theft, and you have about 30% of the population, 33% of the populations that have been victims of retail theft. I know we've had products stolen. The average item that's been stolen, according to that report, is $109 for cost to replace. So this is a bill that is brought forward to try to address and make uniform multiple, again, it says 3 times or more, so it's, or multiple locations where you have somebody, intentionally driving around trying to find, the Amazon or Walmart or whatever boxes on your porch and taking them. So that is the intention. There's another bill that is known as the Inform Act that's in House Commerce that has been going through. Hopefully we'll get that moving. They needed a cleaned up version because the amendment was so extensive, so a new bill's having to be introduced. But overall, effort from the retail industry to try to address theft, retail theft, but organized crime theft as well, because that's a growing issue that our members are starting to see too. So would appreciate your support of this bill, and I'd be happy to answer any questions from the committee.
Sure. Thank you, Eric. Representative Heiberger.
Thank you, Mr. Chair, and thank you for adding this to your bingo list, Mr. Stafford. I have some concerns about that last phrase on lines 19 and 20 of page 2. Refers to a sealed article or thing addressed to a person. It seems like that could apply to something with no retail value at all. Would you consider it an unfriendly amendment to offer to strike that last phrase?
Mr. Chairman and Representative, let me confirm with our membership. I don't think that would be an issue. I think the points that were brought up today, if you're dropping something off, I don't think that's the intent of what we're trying to pick up here. So yeah, Representative, let me confirm that with our membership, but I don't think that would be concerning if they have a reason why that's in there. I'm not sure what it is exactly, but yeah, let me check on that and get back with, can I just get back with you, Mr. Chairman?
Yeah, that's fine. Well, if you or you can get with Boog, we're going to be planning on working this bill on Wednesday.
Okay.
So as long as you'll be in touch before then,
Absolutely.
tomorrow sometime, that'd be great.
Absolutely.
Thank you.
Representative Carmichael.
Thank you, Mr. Chairman. Two areas of inquiry with the chair's permission. First, remind me, what was the nature of the amendment that the chamber believes kept this legislation below the line last year?
Let me look. I think it was property tax related, or I can't remember exactly.
Sure wasn't bundling it with the theft bill?
I was going to say, I think it was an amendment that raised all other theft levels to the $1,500, the threshold to $1,500.
Is that what it was? I
was
can't remember what it was.
Because right now we have
I thought there was another issue brought into it, but yeah, the supplemental report here says, yeah, felony loss thresholds. Yeah, no, I'm not exactly sure, Representative.
Yeah, my vague recollection is that was the compromise that got the bill out of committee, but I may be wrong on that. The second inquiry, again with the chair's permission, you say that our friends in the Commerce Committee are busily at work doing something similar. Can you tell me just in general what they are up to?
Yeah, sure, Representative. And it looks like somebody vandalized your computer. Sorry. So that bill is called the Inform Act, and what that is, it requires high dollar or high volume third-party sellers who sell on Etsy or Amazon or eBay, if they have a certain number of transactions or a certain dollar amount of sales, that they are providing information to the main marketplace, whether it's Amazon or Etsy. And then if they reach a certain dollar threshold, Amazon, Etsy, eBay are required to include the contact information of who that seller actually is. So you have the phone number, address. The issue of concern that's out there from the retail industry is organized crime stealing product and then reselling it through these websites that allow third-party sellers. So it's kind of a registration system. There's a federal compromise that just has not passed Congress yet. And in lack of federal actions, the retail industry is pursuing legislation on a state-by-state basis until Congress acts. So it's more of an attempt to address organized crime versus multiple thefts of product delivered to somebody's house.
Sounds very burdensome to business, Mr. Chairman. Thank you.
Thank you, Representative. Additional questions? All right, not seeing any. Thank you, Eric. Let's see, I see written only proponent testimony from Greg Smith with Johnson County Sheriff's Office. Representative Smith, do you have a follow-up?
Well, I do. In reference to Representative Heiberger's question on an amendment to that and Representative Carmichael's comments about it, it seems to me that, especially in the lines 19 to 20, or I'm sorry, 18 to 19, the question of, or any other article or thing contained therein, what they're trying to get at, if I understand it correctly, is the package is left there and somebody has opened the package and taken something from it. The complication I could see arising is if that happens and the legislation says that they must have removed the package in order for it to qualify, it might just complicate and give our courts another reason to send it back to us. I don't know. That's the way I read it.
Okay, thank you. All right, was there any neutral or opponent testimony? Oh, Representative. Ed, you got something for us? Did we miss this email as well?
Apparently, I'm 0 for 2.
Okay.
And I did resubmit my email I sent earlier. So we'll get that written testimony to you, and I apologize that for some reason it didn't go through.
I assume you're
I
here
swear
for
I didn't leave it on
proponent
a porch.
testimony as well?
I swear I didn't leave it on the porch.
You didn't?
Yeah.
If you would have left
And it is-
cupcakes
It
with
is
it,
proponent testimony.
cupcakes, it might have got stolen if you'd have left it.
That's
without.
right. And I'm still Ed Klump, and I'm representing the three associations, the Sheriff's Chiefs and Peace Officer Association. We support this bill. A couple of things I'd like to point out on it is that this is not a new approach to a multi-theft problem. If you look at the bill on page 1, starting on line 32, a very similar provision was put into the theft statute years ago to address serial shoplifters. We were having a tremendous problem with the serial shoplifters that were actually, they would gather shopping lists from people who wanted products, and then they'd go out and steal them and sell them for, a penny on the dollar. And so we implemented the same approach with the multiple thefts. In fact, it's almost identical except for the definition of mail. It was very effective. We pretty much eliminated that, not entirely, but it went way, way down from what it was at the time. So this is a proven approach, at least in the shoplifting arena. I'll point out that the porch piracy is a growing problem. We have more and more of that happen. And of course, with COVID, more people started ordering online and having these deliveries, and that's proven to be a habit now that is going on. And I know there's been a lot of talk about cupcakes, and I think one of the things that I've heard in past testimony that's important is we even have people getting their prescription drugs now by this method. And so it's not just cupcakes. Sometimes it's things that are very, very important to a person's life. It's more than the inconvenience of a theft. And so we support this bill. We support this approach. We think it's something needs to be done with this porch piracy issue. And what we're looking at is people that within the 72-hour period are committing multiple thefts in different scenes, and then we catch them with that. And the way we generally catch them is we catch them on one, and then we find 10 packages in their vehicle or a search warrant at the home or however we come across that, and we're able to tie the other thefts into a single individual. So with that, Mr. Chairman, I'll stand for questions.
Very good. Representative Heiberger.
Yes, I just wanted to respond to Representative Smith's comments at the appropriate time.
Okay. Were there any questions for Ed? All right. Nope. No questions for Ed. Go right ahead.
Okay, thank you. Yeah, Representative Smith, I was just suggesting striking the phrase "or a sealed article or thing addressed to a person," not to the phrase before that. I think just so that it applies to anything that's actually delivered by the postal service or delivery service, not to something that might have been dropped off by a neighbor, because those things may or may not have value. Okay. That's my intent.
I think I understand what you're saying, Representative Heiberger, and correct me if I'm wrong, but that's what I'm saying. If we strike that and just leave the part about the package, or let's see, mail means a letter, postal card, package, or bag sent through the United States Postal Service or other delivery service, and you're talking about then striking the next after that comma? No. Okay. Natalie's going to help me here. We can't hear you.
Starting with the comma after that, where it says, "or a sealed article or thing."
Yeah, Natalie showed me that now. Okay.
All right.
I'll redigest. Thanks.
Okay. Any other neutral or opponent testimony on SB 408? Okay. Seeing none, we'll go ahead and close the hearing on SB 408. We'll confirm that, Ed, are you planning on testifying tomorrow? We'll make sure that we get that worked out ahead of time. Awesome. Thank you very much. Technology, it's great when it works. All right, committee. As mentioned, we will plan on working both of these bills on Wednesday. So just be thinking about any concerns or thoughts you have there or amendments that we want to make. We'll meet tomorrow for a couple of additional bill hearings. But other than that, I think we're adjourned. Thank you.